The Supreme Court clarified that a person who is not a party to a decree or a document is not obligated to sue for its cancellation. The court set aside the decision of the Guwahati High Court, which, although it agreed with the trial court that the gift deed was validly executed, still allowed appeals dismissing the appellant's suit. This dismissal was due to the appellant's absence of challenge against the subsequent sale deed. A bench of Justice J.B. Pardiwala and Justice R. Mahadevan held that the High Court, having concurred with the courts below on the legality and validity of the gift deed, should not have dismissed the suit only on the ground that the plaintiff failed to pray for cancellation of the sale deed. The High Court should have kept the settled position of law in mind that the declaration of title is as good as a relief of cancellation of the sale deed, or at least a declaration that the sale deed is not binding on the plaintiff being void and thus non-est. The court explained that a plaintiff who is not a party to a decree or a document is not obligated to sue for its cancellation. This is because such an instrument would neither be likely to affect the title of the plaintiff nor be binding on him. Further, the bench emphasized, where the executant of a deed wants it to be annulled, he has to seek cancellation of the deed under Section 31 of the Act, 1963. But if a non-executant seeks annulment of a deed, he has to only seek a declaration that the deed is invalid, or non-est, or illegal, or that it is not binding on him. The court remarked, one should not lose sight of the fact that a suit for declaration of title to be decided by a court takes within its fold consideration of several factors as to how the plaintiff is entitled for declaration of title. In such cases, the plea of the defendants about the validity, enforceability and binding nature of any document defeating the title of the plaintiff have also to be considered. In such cases, the court naturally views the evidence on both sides, leaving apart the frame of the suit. Section 34 of the Act, 1963 is not exhaustive of the cases in which a declaratory decree may be made, and the courts have power to grant such a decree independently of the requirements of the section. Section 34 merely gives statutory recognition to a well-recognized type of declaratory relief and subjects it to a limitation, but it cannot be deemed to exhaust every kind of declaratory relief or to circumscribe the jurisdiction of courts to give declarations of right in appropriate cases falling outside Section 34. The circumstances in which a declaratory decree under Section 34 should be awarded is a matter of discretion depending upon the facts of each case, the bench explained. Consequently, the court ordered, in the result, the appeal succeeds and is hereby allowed.